Good morning, everyone. My name is Lauren Holden, and today we're going to be talking about financial advising law. Financial advising law is a set of rules that govern people and firms who give investment advice for compensation. The goal is to protect investors and ensure that the advice is honest, fair, and free from conflict of interest. Some general laws and regulations regarding financial advising include the Investment Advisors Act of 1940, which is a federal law that mandates that investment advisors must register with the SEC, adopt a written code of ethics, and establish policies and procedures to ensure compliance. Just for some context, the SEC is the federal agency that protects investors by enforcing rules against fraud. They must follow compliance rules. Firms must designate a chief compliance officer and maintain compliant policies and procedures. Virtually, they just keep a watchful eye and make sure that none of the advisors are doing fraudulent activities. They must keep up with licensing and registration. Advisors have to pass specific licensing exams to operate within a state, which in California is a Series 65 or the Series 66 and 67, and they must register with the state securities regulator if applicable. Advising firms must follow state-by-state rules against unethical business practices. And last but not least, the concept of fiduciary duty, which is the rule that advisors must act in their client's best interest, and that is what our case today gets into. So, kicking it off with the Securities and Exchange Commission versus the Capital Gains Research Bureau Incorporated, and here is a short introductory video on that.
Well, hi, and welcome to our office. I am an advisor with Capital Research Group, Inc. What can I do for you today?
I am an investor and I am looking for a stock to buy. Please recommend me something.
Oh, you've come to the right place. We've got some really good investments. You've heard of AI? This is superai.com. I can get you in on the ground floor. I've already convinced all of my other clients to buy millions of shares that I purchased weeks ago. I'm gonna let them buy, it'll go up, and I'll sell my shares at a profit.
Sounds good. I will take 1 million shares. Now let's get into the relevant facts. The Capital Gains Research Bureau was an investment advisory firm that published newsletters recommending certain securities. Between March 15th, 1960 and November 7th, 1960s, advisors purchased shares of a security shortly before recommending it in the newsletter. Then on each occasion, there was an increase in the market price of the recommended security within a few days after the distribution of the newsletter. Immediately after the price went up, the advisor would sell their shares at a profit. This is a practice known as scalping, or otherwise known as pump and dump schemes. The firm obviously did not disclose this practice to its subscribers, and this occurred on 6 separate occasions. The SEC finds out and sues for an injunction, arguing that this non-disclosure was fraudulent and deceptive under the Investment Advisors Act of 1940 because it created a conflict of interest. Now this begs the question, does an investment advisor's failure to disclose conflict of interest, in this case scalping, constitute a fraudulent or deceptive practice under Section 206 of the Investment Advisors Act, even without proof of intent to defraud? It was obviously unethical and for the personal gain of the advisor, but it didn't necessarily cause harm or show intent to cause harm to the client. The controversy arose because the parties/courts disagreed about how broadly the word fraud should be interpreted in the Investment Advisors Act. The main rule in question here is the Investment Advisors Act of 1940, specifically Section 206. Section 206(1) prohibits the use of any device, scheme, or artifice to defraud clients or prospective clients. Section 206(2) makes it illegal to engage in any transaction, practice, or course of business which operates as a fraud or deceit on a client. And Section 206(4) prohibits any fraudulent, deceptive, or manipulative act, practice, or course of business. Now, taking this rule into account, the Capital Gains argued that scalping might be unethical, but not fraud unless the SEC could prove that they intended to deceive someone. No subscriber testified that they relied on the advice or suffered injury, so no client actually suffered harm to their portfolios. Therefore, the SEC couldn't prove fraud and no injunction should issue. Basically, Capital Gains was saying that they did not lie, so it isn't fraud. However, the SEC argued that Congress intended advisors to be fiduciaries, even if the word wasn't explicitly stated in the act, requiring them to disclose any conflict of interest. Non-disclosure of a conflict is deceptive, and it's enough to violate the act. The act is preventative, so the SEC doesn't need to wait for harm to actually happen to prove that traditional common law fraud. So the SEC is basically claiming that non-disclosure is virtually lying, so in this case, the Capital Gains Research Bureau did commit fraud. And now for the ruling. When this first went to court, the district court denied the SEC's request for a preliminary injunction because they believed the SEC had failed to show an intent to injure clients or an actual loss of money to clients. Of course, the SEC appealed, to which the Court of Appeals for the Second Circuit affirmed the denial of the injunction. However, the Supreme Court reversed the decision of the lower courts. It held that the Investment Advisors Act requires full disclosure of conflicts of interest, and the SEC doesn't need to prove common law fraud. Scalping is fraudulent under Section 206 because it deceives clients who expect unbiased advice from their advisors. Bottom line, this ruling is a massive win for clients. It creates the foundation of fiduciary duty, consumer protection, honesty and conflict disclosure, and SEC power to regulate advisors aggressively.
And as advisors, what do? We get more rules, more restrictions, and more liability. As we should.
Thank you for listening.